Karalynn. Welcome back to the podcast. And today we're going to talk about incorporation, why it's important, what you need to do to keep it, and ways you waive your corporate protection, right? Um, so, why you need to be incorporated. Okay, so the business needs to be its own entity. And to be its own entity, you need to register with your Secretary of State or wherever corporations are filed in your state. And what that does is that makes any liabilities, either, when you bills, things that happen on the job, injuries, that kind of stuff, anything that may happen, it says that once you're incorporated, only the business assets would be up for grabs if something goes wrong, right? If you can't pay the bills, you have to go bankrupt or an injury happens, only the business assets are up for grabs. It protects you personally, right? So if you are in business and you have a DBA, an assumed name that is not incorporating, right? So that's basically no protection. That just says you're doing business as this name, right? You actually have to file and be incorporated in the state where you're at, right? And what that incorporation does is, like I said, it says, like, if you are unable to pay a credit card bill or that's in the company's name, or you can't pay a bill that's in the company's name, then when you're sued, the only assets that are up for grabs are the company's assets. And if the company doesn't have any assets, then there's nothing to get, right? There's nothing to go after. It protects your personal assets, your home, your personal checking account, the cars that you drive, any extra boats or ATVs, any extra properties that you may have that you own individually. If you don't have a company, that is all up for grabs by any creditor, right? So, God forbid you're not incorporated, something happens on the job, somebody gets injured, and we're talking hundreds of thousands of dollars, and you're not incorporated, they're going to sue you individually and go after your personal assets. Now, what's up for grabs can depend on the state that you live in, but still it's the availability, and it'll be on your personal credit. It'll be, for as long as that takes, it'll be a personal judgment against you, as opposed to where if you had a corporate structure, if something like that happened, they're going to sue the company, right? And then the company's assets are up for grabs and not your personal assets. So it gives you a level of protection to protect your family, your personal, everything you work for, that just if something traumatic happens to the business, that you're still protected, right? And so, you should do this as soon as you decide you want to start a business. If you haven't done it already, that's okay. Do it now, right? We do incorporations in all states. We can help you with that for a flat fee. There's places online that you can do it. You just need to make sure you get it done. If you're not, you have, all of your family's assets are up for grabs if something goes wrong. Now, I know there's always a lot of questions about what kind of entity do I want to file? Is it a corporation, LLC, a partnership? From a legal perspective, there's really not a whole difference. Like, as long as you're incorporated, you're protected. That's more, a C Corp or an S Corp. Those are more of tax questions and based on your own individual tax reasoning. And you should really talk to a CPA about the different types of entities that are out there that you can choose from, right? And it depends too also on, is it just you, or you're going to have more people involved, or is it just you right now? You may have people in the future, right? If it's more than just you, I would recommend an LLC because it has multiple members. And then once you do form a corporation, if it's just you, that's fine. If you're going into business with multiple people, I would recommend a corporation and an operating agreement that says who's in charge of what. And then the most important thing is what happens when somebody doesn't want to be a partner, or what happens when somebody's not doing what they're supposed to, right? Because if we have that in writing on the front end, once we get into a situation that no longer works, it becomes easy to separate, right? If you don't have it in writing, it becomes a huge mess. You don't really have a lot of leverage. You'll probably have to go to court, because I've seen these situations get very sticky, right? And it's even worse if it's family. So especially if you have family, have it in writing, because you never know what's going to happen. You never know how somebody's going to act. You never know, what's going to happen with the business. Be incorporated, have an operating agreement of how things are, who's in control of what, right? Who can buy property, who has access to the books and records, who can take money out, how can they take money out, who's in charge of the bank accounts, who has access to that, right? Having that all spelled out. And then what happens if somebody starts acting against the best interests of the business, right? They start taking money out of the bank account that wasn't approved, right? And so having that all spelled out, it gives you the tools to deal with it when those situations happen. I hope that they don't, right? But I've seen the sides when they do, and it gets very messy, very expensive, especially when it's a straight 50-50 ownership. It can be a long, painful process. At the same time, you're still trying to keep your business going, and this other partner or this other person in your business may be doing great harm to your business, and your hands are really tied. To get it resolved quickly, it would be a court process, something very expensive and time consuming, and especially in a situation like that. But at that point in time, you're just tired of each other and you want to get away from each other. So having that built into the agreement, hugely important. And so really taking the time when you're going to go into these things. And I've seen some great partnerships and great things happen, but take the time when we decide to go into these relationships to document in writing, signed by both parties, you know, and really make sure that it gets done. Who's going to be in charge of all this stuff? Who has the right, can you just sell your shares to anybody if you want to leave? How are we going to value the company? So we can determine what the buyout's going to be, to let somebody go. If their salary, if they are also working for the company, what happens when they stop working for the company? Do they get to keep drawing a salary and not doing anything? Kind of what are those expectations? What does that look like? Just being upfront about everything. Like any other contract, it's to manage expectations. And if we don't know what to expect, that's when things get out of hand, and can get really expensive. So I told you why the corporate structure is important, right? Protect your personal assets. So once you incorporate, you truly need to treat your company as its own entity. And here's why it matters, right? Because if you don't treat the corporation as its own entity, as it's truly its own business, then if you do get sued, they could do what's called piercing the corporate veil. That even if you have a company, if you haven't treated it that way, then your personal assets can still be up for grabs. It's a hard thing to prove, but what they're going to look for is, does your company have its own bank account? That you're not paying your personal expenses out of that own bank account. You take a salary or a paycheck just like every other employee. If you start treating the business as it's no different than your personal checking account, it could be your corporate structure could be challenged, right? And taken away in a litigation situation. So making sure that once you are incorporated, that you take the steps to make sure that it's treated as its own bank account, has, it only pays the people that work for the company. Everything that runs through there is for the business, right? Making sure that we keep that corporate structure upheld. Another important thing that usually gets overlooked is that usually most states have annual reporting information, and it may just be reporting like who's the current owners. Some states have franchise tax requirements. If you don't do that, what'll happen is your corporate structure will lapse, right? If you don't file your annual reporting with, like in Texas, most states it's Secretary of State. Some states it's called something different. But if you don't file your annual reporting, what'll happen is they'll they'll forfeit the business, right? And so one day you'll get sued, and they'll be like, why are you suing me personally? Well, because your business is forfeited, right? Most states have where if you get forfeited, you have a certain amount of time to go back and fix it. And it's like the company was never forfeited, right? And so filing those annual reports are hugely important. You can ask your accountant about it. You can go check your own status on the Secretary of State and see what you need to file. You can always call them and find out. But making sure that annual paperwork is filed is hugely important, because if it's not, like I said, your entity will be forfeited, and it's just like you had no entity. And then again, your personal assets are up for grabs, right? And then there's certain situations, especially in the construction industry, where you knowingly waive your corporate protection, right? And so we talked about what corporate protection is, protecting your personal assets. So there are some situations where you waive that. So most commonly, what you're thinking of, if you sign a personal guarantee, right? You are waiving your corporate structure and saying, hey, yes, you can have my company assets, but you can also have my personal assets are now up for grabs to satisfy any debt that I may owe you, right? And so it's another thing important too when we're talking about signature lines for companies. If you're signing on your behalf of your company, make sure it has your title and your company name. So it's very clear that you're signing on behalf of the company and not your individual capacity. If you just sign your name and it just says, doesn't say who on behalf of you're signing of, there could be an argument that you personally guaranteed whatever you're signing, right? So most commonly, I see personal guarantees in credit apps with material suppliers, right? On the bottom or towards the end of the credit app, there'll be a signature line for your company and there'll be a signature line for you personally. When you sign that, and some material suppliers or some companies won't let you get out of signing their agreement without giving them a personal guarantee, right? So that's a risk you got to take. When you sign that, you're saying, yes, you can have my company assets, and if that's not enough, my personal assets will be available to satisfy any debt that I might owe you, right? And so really realizing what that means when you sign a personal guarantee, right? And when you're not signing a personal guarantee, any other document that you sign on behalf of your company has your name, your position in the company, and the company's name, right? Because that is hugely important to make sure that you're not accidentally waiving your corporate protection. Okay, another situation where in the contracting industry, first I wanted to bring up, it is not standard practice to have a personal guarantee be part of a subcontract or any kind of residential construction contract. It is not standing operating procedure to have a personal guarantee as part of a construction contract. It's just not. In most cases, if anybody asks for it, I wouldn't. Number one, I wouldn't don't sign the personal guarantee part. That way, it doesn't become a personal guarantee. I have seen subcontracts and other contracts that have personal guarantees. Don't sign those because they're not what's common. If you're going into, especially if you're a residential contractor, going into a contract with a homeowner or somebody that's building a new home, and they want you to sign a personal guarantee, that is a red flag. Do not sign it. Push back on that. That's one thing I would not, under any in that situation, I would not sign in any circumstances. So a personal guarantee of part of the contract is not normal. Do not sign. That being said, if you are, and this mostly happens in commercial construction, if you are required to get a bond, those will have personal guarantees. Absolutely. Not, personal guarantees, and you're pledging all your assets in order to get that bond. That is quite common. But do realize that when you get that bond is not insurance, right? If there's a claim filed on your bond and the bond company pays out, you are then on the hook to pay the bond company back anything that they have to pay out. So, and then you've signed the personal guarantee with the bond company with the surety. So now it's not just your company, it's your personal asset. So bonding is mostly required in all federal projects. Just understand that you're signing. And there's in the construction industry, there's two types of bonds that you're normally required to get, is a performance bond and a payment bond, right? And the performance bond is guaranteeing to the person that hires you, the general contractor normally, or if you're a general, to the entity that's hiring you, that you will complete the performance of the contract. And if you don't, then they can file a bond claim on that performance bond, and the bond company will then pay for the completion of the project if you abandon it or leave it or can't finish it for some reason. And then if that happens, the bond company is coming after you to get those funds back, right? And again, you've waived your corporate protection. So the second type of bond is the payment bond. And this says, I guarantee that I will pay all the people and the material suppliers that work for me, right? And if you don't, they can file a claim on your bond, the bond company will pay them out, and then you owe the bond company again. So these are one of the big ways that I don't know if you realize that you're waiving your corporate protection if you're getting a bond in the construction industry, right? So one of the big rules I say, if you're getting a bond in any type of project and you're a subcontractor, make sure you get a copy of the general contractor's bond. That way, if you're unpaid and somebody, one of your material suppliers tries to file on your bond, you can file on the general contractor's bond to get paid, right? So it's some protection built in for the fact that a claim could still be filed on your bond if you haven't been paid. So, if you're getting bonds for the first time or doing public works jobs for the first time, let's have a conversation of how those are different than normal commercial projects, what it looks like, because they can be risky situations, especially when they're requesting you to get a bond. If you haven't got one before, it's pretty, they're going to check your credit worthiness. It's a pretty intense process. So, why you need to be incorporated, the different types of corporations, um, keeping your corporate structure as its own business so you can keep your corporate protection, and situations where you knowingly waive the corporate structure to have a get material on credit or get a bond in a job. So if you have any further questions about any of these, feel free to email me, tag me on LinkedIn, Facebook, anywhere, or leave me a note. All right. Thanks, guys.